Thank you very much for inviting me to speak to you today. I must start off with an apology. You've not got the DPP who was originally invited to speak today. Keir Starmer has just left us to go back into private practice, and Alison Saunders has just taken up post. So the timing of this conference was unfortunate for us because of that handover. Otherwise, I know both would have been very keen to be here. Both have taken a very keen interest in the problem of organised crime in the United Kingdom. Indeed, as some of you may know, Alison was previously the head of the Organised Crime Division at the CPS between 2005 and 2009. She's therefore very knowledgeable about this area and the problems and challenges involved in prosecuting organised crime cases. I do think it will be of enormous value to the CPS to have a DPP who has a real understanding of this area. I also think it will be of enormous value to some of our partners. I'm afraid I'm going to have to tell you a little bit about the way the CPS is organised so that you can understand the overview of the CPS approach. The CPS is divided into 13 areas. Each area is headed by a Chief Crown Prosecutor, and additionally there are 3 central casework divisions, again headed by a Chief Crown Prosecutor. One of these central casework divisions, the Organised Crime Division, which I head, exclusively prosecutes organised crime cases. Up to the 7th of October of this year, that meant we prosecuted cases investigated by soccer. Since the 7th of October, we now prosecute on behalf of the NCA. I've got about 70 staff in London, Birmingham, Warrington and Calder, the latter 3 co-located in NCA offices, whose sole role is to prosecute organised crime cases. I'm also looking to see if I can to co-locate my London team in with a London branch of the NCA. That enables us at the CPS to deploy a specialist response to any investigation undertaken by the NCA. That specialist response is deployed within 24 hours of a case being tasked through the NCA tasking procedure. If necessary, a prosecutor can be allocated within minutes. A specialist CPS prosecutor is therefore available from the earliest stage to give real-time operational advice to an investigator. The specialist response doesn't end there. Within the Organised Crime Division, I also have responsibility for about 90 staff dedicated to taking the criminal assets away from criminals. The CPS is therefore able to deploy specialist asset forfeiture lawyers to ensure that serious organised criminals do not benefit financially from their offending. These lawyers can handle complex restraint and confiscation applications and ultimately deal with enforcing confiscation orders obtained in our proceedings. They're able to give specialist advice to financial investigators. There are also a number of CPS lawyers attached to various regional asset recovery teams. And in total, around the country, there are about over 100 lawyers nationally devoted to asset forfeiture work. And that's a considerable investment on our part. Well, does the system work? Well, our performance data tends to indicate that it does, but most performance data can tell you what you want it to tell. The conviction rate, though, is quite interesting. For cases prosecuted by the Organised Crime Division, it's been consistently around the 90% mark. Now, in terms of Crown Court conviction rate, that's very high. The rest of the CPS obtains roundabout in the Crown Court roundabout high 70s. And over the last few years, we've taken over £500 million seized from criminals. And each year, the amount seized from criminals has increased. But the response doesn't end there. You'll recall that I mentioned that the CPS is divided into 13 areas. Each of these areas has a complex casework unit, and these complex casework units prosecute organised crime cases investigated by individual police forces. There are varying size. The biggest is in London, services the Met. There are others around the country. The biggest ones tend to be in the urban metropolitan areas. These CCUs can provide an allocated lawyer to a police investigator, so again that the investigator has access to a specialist prosecution advice from an early stage in the investigation. It's these CCUs that will service the work that is to be investigated by the regional organised crime units. And they form a key part of the NCA strategy in combating organised crime. And I'm sure Keith Bristow will mention those ROCOs later on today. But there's an international dimension to this as well. The CPS has liaison magistrates in various jurisdictions, currently in the United Arab Emirates, currently in the United States, France, Spain and Italy, together with dedicated CPS staff in other jurisdictions as diverse as Afghanistan, various Caribbean countries and Tanzania. Consequently, as organised crime becomes more international, the CPS has developed an international response to aid prosecutors and investigators in combating that threat. These liaison prosecutors are available to assist with the drafting of complex letters of request, queries about extradition, and queries about local criminal justice procedure. They're also invaluable in unblocking delays that can sometimes occur in complex international jurisdictions. Okay, having given you the overview, I'm going to set out some of the particular challenges and limitations in prosecuting these type of cases and what we try to do within the organised crime division to meet these challenges and mitigate the risks. Well, there are a number of challenges in prosecuting these cases. These include, but are not limited, and there are many that I won't mention. The first one is the sophistication of the defendants. The defendants involved in this type of offending are often highly intelligent and highly organised. Run-of-the-mill investigative techniques are not often appropriate against such individuals, and the techniques have to be proactive and innovative. They can also be time intensive and expensive. Prosecutors dealing with this type of case must have expert knowledge of a number of areas. RIPA, the Fraud Act, POCA, Police Act 1997, Serious Crime Act, the Serious Crime Prevention Orders, and powers specifically under Section 71 to 74 of the Serious Crime and Police Act. That's not the skill set of a standard prosecutor. It requires a highly specialised skill set. Not all prosecutors are suited to this type of work. It requires a forensic attention to detail and an ability to build a case piece by piece so that, if necessary, a strong inferential case can be put before a jury that shows the involvement of a defendant against whom there may be actually very little direct evidence. These type of defendants are also highly sophisticated in hiding their assets, a matter to which I shall return later. I want to turn to the resources involved in investigating and prosecuting these types of cases. The investigation can take months, sometimes even years. Care has to be taken that the expenditure of these resources is not wasted by decisions made at an early stage that may compromise an ultimate prosecution, or that merely may prove to be irrelevant to any future prosecution. A fraud investigation or a prosecution may involve thousands of documents and may take an investigator along many investigative strands. Do those inquiries need to be done? What are we seeking to achieve by the investigation prosecution? Should we concentrate more on the flow of money and change the emphasis of the investigation from one of fraud to one of money laundering? Would this be easier to prove? Would it deal adequately with the underlying criminality? All these questions require proper communication between investigator and prosecutor. Prosecutors need to be appointed quickly to a case to assist the investigator, and a clear prosecution plan needs to be drafted to ensure that the case is progressed to a successful prosecution. Again, I'll return to this matter later on. I want to turn to the international profile, which has already been touched on. Many of these cases have an international dimension. Prosecutors need to have an expert knowledge relating to the drafting of letters of requests, as evidence can be located abroad, especially in drugs-related cases where the drugs are usually imported from abroad. Suspects and defendants will often be based abroad, or in some cases may flee abroad when enforcement action is taken. Prosecutors need to have expert knowledge of the law and practice of extradition, and again, this is not necessarily within the skill set of the standard prosecutor. Prosecutors need to be confident in dealing with different jurisdictions, and also using European institutions such as Eurojust to facilitate proper international cooperation. The fourth challenge is the speed at which these cases can progress. Despite the fact that a number of these cases can take a long time to investigate, sometimes things can progress really rather quickly. Prosecutors need to be available outside of office hours to give real-time investigative advice and charging advice to investigators with suspects who are either under observation or may be in custody. In the Organised Crime Division, our lawyers sign up to be available 24 hours a day, 365 days a year. There is a duty rota so that a lawyer is available 24 hours a day to provide urgent charging advice and advice on any investigative matter. Lawyers are expected to provide investigative advice out of office hours on their own cases. If advice is required outside of office hours, it has to be provided. Lawyers who are not prepared to sign up to this will not work on the division. It requires a whole different mindset from prosecutors. The mindset also has to allow us to come up with innovative solutions to complex issues. Because of the sophistication of the suspects involved in this type of criminality, standard investigative and prosecution techniques are not always appropriate. Prosecutors may need to consider the powers under Section 71 to 74 of SOCPA and may need to use these powers in respect of really some quite unsavoury individuals. Prosecutors may need to consider the use of serious crime prevention orders in respect of some individuals, sometimes as an alternative to prosecution. These tactics sometimes lead to criticism of prosecutors. But no discussion about the challenges of prosecuting organised crime cases would be complete without a consideration of the problem of disclosure. When evidence is obtained against organised criminals, it can often be quite compelling. It might be contemporaneous recordings of incriminating material or evidence from cooperating witnesses. Very often, the person charged will not want that evidence going anywhere near a jury, as if it does, there's a real risk of conviction. The approach many defendants take is to attack the process of the investigation and the process of the prosecution. The most common method by which this is done is to attack the disclosure process. A careful strategy must be devised to ensure that all relevant unused material is identified, it is scheduled, and is considered so that a proper disclosure decision can be made. And more importantly, so that it can be demonstrated to the court that a proper disclosure decision has been made. Frequent applications alleging an abusive process are made because of alleged disclosure failures. It can be extremely resource intensive to carry out a proper disclosure exercise, but experience has shown that failure to do so will lead to disaster. So how do we try to deal with some of these challenges? Well, as I said, we try to appoint a prosecutor within 24 hours of the case being passing through the tasking procedure, previously of SOCA, but now of the NCA. So the prosecutor is involved at the earliest stage of the investigation and will be there to assist in the drafting of a proper prosecution strategy that will help guide the investigation through to a successful prosecution outcome. What we also try to do is hold what's known as an early case planning conference with the investigator within 7 days of the prosecutor being appointed. What we try to do is to try to bring business planning techniques to this process. The early case planning conference is attended by the SIO, the investigation officer, the disclosure officer, the prosecutor, and anyone else who has a critical role in the case, for example, a humans officer. At this conference, all the parties work together to develop a strategy to take the case to a successful prosecution. Proper plans are agreed for dealing with certain evidence, including agreeing a proper and realistic timescale, which is important if you've got defendants in custody, which a number of these defendants can be. Agreement can be reached as to what forensic evidence is required and precisely what that forensic evidence is required to prove. The thorny evidence of telephone evidence, which is key in this evidence, can also be discussed, and a timescale for delivery of that evidence. Crucially, the complex question of how disclosure is going to be dealt with is discussed and agreed. Are there third-party inquiries that need to be made? If so, with whom? How long will those inquiries make? Does it need CPS input? Is there any sensitive material? How are we going to deal with that sensitive material? What's the position of the investigator or the investigative agency if a court rules that we have to disclose that material? All this is agreed at an early stage so that we have a strategy to take us through from A to B. The notes are circulated and agreed by all parties, and they provide an audit trail and a reference point for all involved and can remind all involved, should they need to be reminded, as to what was actually agreed by all parties at an early stage. Following this early case planning conference, the prosecutor will draft a prosecution strategy document and a disclosure strategy document. These are, to use a phrase, living documents that are kept updated through the life of a case. The disclosure management document is drafted with a view to service on the defence and will set out clearly the prosecution strategy for dealing with disclosure. It's served at an early stage, and an order is sought from the judge ordering the defence to set out any objection to the prosecution approach within a reasonable period of time. The purpose of this is to avoid those late ambush disclosure requests that often come in from defence lawyers. In a recent case, a defendant made such a request on the first day of trial. The judge dismissed the application on the basis that the defence had been in receipt of the prosecution strategy for a number of months. They had not objected to it, and the judge was satisfied that the prosecution approach was a reasonable one. Additionally, my unit heads attend all NCA quarterly reviews where they go through all the cases in their area. This enables further joint working and joint strategies to be developed for problem solving. And we now do debriefs at the end of every single case that goes through the Organised Crime Division. We identify what went well, we identify what didn't go well, and we take the learning from that. The good learning can be shared, as can the learning from any mistakes made. It provides us with an evidential basis for both good and bad practice. A good recent example of thinking in a different way was the SCPO obtained against Curtis Warren. As many of you will know, Mr. Warren is a lifetime criminal with convictions going back many years. He has recent criminal convictions in Holland and is currently in prison in Jersey. Much of his offending revolved around drug trafficking. He is currently coming to the end of his sentence in Jersey. Given his history of offending, there was a real likelihood that if he was released and came back to the United Kingdom, he would continue to offend. As there was no current evidence of criminality, a decision was made to apply for a High Court Serious Crime Prevention Order under the Serious Crime Act of 2007. Mr. Warren refused to cooperate with the proceedings, but they continued without his cooperation. The NCA and the CPS worked very closely together to obtain the strongest possible evidence against Mr. Warren, and eventually he consented to the order being made. The exact terms of the order are in the process of being agreed by the High Court, but the terms will enable us to prevent him becoming involved in future criminality, or at least to make it more difficult for him to become so involved, because I don't think with these sophisticated defendants you ever have complete control over them. This was the first order of its kind obtained by any prosecution agency. The order is a civil order, but the breach of the order, any breach of the order, is a criminal offence punishable with up to 5 years imprisonment. So the order has real teeth and enables us to exercise some more control over Mr. Warren than we would have been able to do otherwise. I've set out our current major challenges. Nothing is, however, static in this environment, and whilst those challenges are likely to remain, others are likely to develop. I've tried to look into my crystal ball and anticipate some of these challenges. These again include, but are not limited to, the following. We've talked about the definition, and not getting too tied up in the definition of organised crime. Well, it's always been rather tricky, and we've a long time shied away from trying to define it. Traditionally, we've taken very much a you'll know what it is when you see it approach to it. This is all very well, but it's tended to mean that we've concentrated on particular types of offending. And traditionally, that has meant drug dealing and money laundering. It's those offences, I think, that we traditionally think of when we talk about organised crime. It's certainly what my staff think about when they think about organised crime, because that forms the bulk, the vast bulk of the casework that they do. Is this going to continue in the future? Well, drug dealing is, of course, serious offending and causes untold harm to communities. There will continue to be a focus on this type of offending, but organised criminals do more than drugs. They carry out fraud, both fiscal and non-fiscal, and are involved in almost every sort of acquisitive crime. They're involved in trafficking, sexual crime, and increasingly in cybercrime, to which I will return later. In fact, you name any crime, well, any serious crime anyway, and it is probable that organised criminals will be involved in it. Now, the NCA will focus on serious crime, not serious organised crime like its predecessor, soccer. It will not define serious crime narrowly. Its focus is likely to be on the harm caused to communities by criminals. It's not likely to confine itself to a narrow category of offending. A sad recent example shows that Dale Cregan killed 2 police officers in Manchester, but he did not map on to the most serious criminals in the country. Previously, my lawyers have spent much of their time prosecuting drug crime. I think that we in the CPS are going to have more varied skills than that. Lawyers in the Organised Crime Division and the wider CPS are being trained in the prosecution of cybercrime and prosecuting sexual crime and a new approach to prosecuting sexual crime, because these are areas which are going to be much more important to us in the future. Within the Organised Crime Division, we've already started prosecuting cases of serious violence associated with organised crime. Consequently, what we define as organised crime is likely to change, and the CPS is likely to be prosecuting a different caseload to that which it has traditionally prosecuted in organised crime cases. This is going to be a challenge for us. I want to talk briefly about asset forfeiture. I mentioned earlier on that over £500 million have been taken from criminals in the last few years. Well, that's the good news. The bad news is that the current debt in unpaid and unforced confiscation orders is approximately 1.4 billion. I repeat, 1.4 billion. So whilst we have undoubtedly made significant progress in seizing the assets of criminals since the advent of the Proceeds of Crime Act, we need to do better. We're currently examining our high-profile orders and assessing what percentage of those confiscation orders are actually enforceable. What percentage of the debt is said to be constituted by hidden assets? What proportion is abroad? What proportion is subject to third-party claims? We will then concentrate on enforcing that debt that is properly capable of enforcement. We are currently looking at where those assets are. If they're abroad, do we need to put CPS staff in problem jurisdictions to assist in the enforcement of these orders? Do we have all our dedicated staff in the right place? Is there a need for a national service in the CPS to deal with this type of work in the same way that we deal with national charging? I think that we will see a continued emphasis on this work in the next few months. The interest in this area goes to the very top of government, and we're going to have to respond in the CPS to that interest. That again is going to be a challenge for us and every other agency involved in the process. I want to talk about the problem with the legislation. I don't want to use problem in a pejorative sense, but the way that we prosecute cases can sometimes be quite difficult. The traditional tool of the prosecutor in dealing with serious organised crime is to use the offence of conspiracy. Conspiracy is a very good offence for prosecutors because it focuses on the agreement to commit a crime rather than the actual crime itself. And if you speak to prosecutors, practically it means that you can get all the evidence in as of right. You do not have to wait for the crime to be committed for the offence of conspiracy to be committed. The offence is committed when the criminal agreement is entered into. The problem with the offence is that the mental element of the offence, the mens rea in legal terms, is intentional knowledge. That's a high threshold, and has often meant that the arrests are often made just before the offence is committed or even as the offence is committed, in order to show to the criminal standard the necessary intentional knowledge. A further complicating factor is that most serious criminals are rarely hands-on, and this leads us to having to rely on inferential evidence, for example from telephone evidence, to prove our case on an inferential basis. We therefore need very good evidence to prove a conspiracy. Other legislation is also slightly problematic. Anyone who has sat down and tried to understand section 44 to 46 of the Serious Crime Act 2007 will testify to the tortuous nature of that legislation. The threshold for that offence is no less than belief. Again, in criminal terms, a high threshold. Actually, not much lower than knowledge. Consequently, we're working with the Home Office and other partners, including Gordon Meldrum at the NCA, to develop or seek to develop a new offence of participation in organised crime with a mens rea that mirrors the Proceeds of Crime Act 2002, i.e. knowledge or suspicion. This will give us as prosecutors a range of offences to deploy against organised criminals, and that properly reflects the evidence that we have against them. However, it will require proper scrutiny on our part to ensure that prosecutors do not take the easy option and plump for the participation offence in all circumstances. Prosecutors must prosecute the most appropriate offence disclosed by the evidence, and if evidence of conspiracy is available, that is what should be prosecuted. Ensuring this happens and maintaining public confidence will be a challenge for us. I just want to touch briefly on resources because it's been touched on before. Resource cuts are currently a challenge for all agencies in the criminal justice system. I don't want to make a lazy assumption that cuts to resources automatically mean there will have to be cuts to the quality of the service that the CPS can provide to law enforcement agencies. As a service, we're going to have to get smarter as to how we deploy our resources. The simple fact is, however, that we have as a service now approximately 2,000 staff less than we had in 2010. That is bound to have some effect on the way that we operate in future. I mentioned earlier that all areas, 13 CP areas, had a CCU. However, most of the organised crime occurs in urban areas. As Martin says, not all of it, but most is concentrated in the urban areas, and predominantly in the northwest, the northeast, the West Midlands, London and the southeast. Consequently, we may need to take decisions about concentrating our resources in these areas to provide that dedicated expert response to investigators. It may mean that officers outside these areas may need to travel further to get that expert response. It's not ideal, but it may be necessary in a time of shrinking resources. But I believe that the CPS and law enforcement agencies are going to have to work much more closely together to overcome these problems, as there is not going to be so much fat in the system to absorb short-term resource pressures. As Martin says, there's silo working within the police, but agencies within the criminal justice system tend to operate on their own priorities, and we all operate different priorities which may not be particularly conducive to close working together. I don't think we can afford to do that anymore. The communication between us is going to have to be much better so that we can both get the best out of our resources. One way that I've tried to improve this communication with the NCA is to have a much closer liaison with the NCA tasking process. Every month I get an update from them as to what is in the pipeline and where that work is likely to go. I will be able to plan my resources accordingly and crucially inform my Chief Crown Prosecutor colleagues of any work that is likely to come into their areas through the ROCUs. That in turn will enable them to plan their resources to provide a proper prosecution response to law enforcement colleagues. I think that's the way forward for all of us, better communication and more joint working. I want to finish off with two challenges that have been touched on already, the challenge of cyber and the challenge of fraud. And I think the next few years is likely to see a greater emphasis on combating this type of offending. It's going to be a challenge for everyone because these cases contain a number of challenges in prosecuting organised crime cases that I've already mentioned. In particular, the challenge of disclosure in a cyber case is considerable. Literally millions of documents can be held on computer files, and just sifting this information can be a real challenge and can suck in resources. But in the CPS, do we have the expertise to handle these type of cases? The investigation that requires a specialist investigator, and prosecution of them certainly requires a specialist prosecutor and a specialist advocate. Otherwise, matters can rapidly become confusing to a jury. Does this expertise exist in law enforcement agencies? A matter that Martin has already raised. But does it exist in the CPS? Do we have the staff who really want to do this work? Most of my lawyers, give them a choice between doing a fraud or a cyber case and a good bit of drugs or a good bit of violence. They'll plump for the drugs or violence every time. They don't want to sit down with hundreds of thousands of documents and read through it. That's the challenge for us. And a particular challenge is thrown up in CEOP cases, particularly those involved in online grooming and sexual abuse, bullying and blackmail. This is a growing area of work. In the blackmail cases, sometimes the victims of the blackmail may be abusers themselves. That's why they're being blackmailed. To prove the case, you may be reliant on evidence from individuals who are not going to be sympathetic to a jury. How should investigators and prosecutors approach these individuals? These are very difficult problems that require very careful consideration and present a particular challenge to prosecutors. The Home Office has provided welcome funds to prepare agencies for these challenges. We're busily training staff to prepare them for the challenges of prosecuting this type of casework, which will undoubtedly come. The flip side of that is that the Home Office will undoubtedly expect to see many more prosecutions of this type of offending in the very near future. The complexity of this area of offending and the amount of resource necessary to properly investigate and prosecute it will be a challenge for all of us. Dealing with fraud, I don't want to say too much about this because it's a topic in itself. What's clear is that the problem of fraud and the scale of it has arguably not been properly appreciated or tackled for some time. Experience in investigating and prosecuting fraud is patchy around the country. Staff who like fraud tend to be passionate about its investigation and prosecution. The problem is that no organisation has enough of these type of people. Fraud, however, continues to be a major problem, and it's estimated that it costs the UK many billions of pounds every year. Current estimates are that it may be up to about 50 billion. Intelligence also shows that criminals who commit serious drug crimes, serious other types of organised crime, will also commit fraud if the opportunity arises. It goes without saying that the resource challenges of this type of work is considerable, especially in the current environment. The CPS has recently taken on the prosecution function for the DWP. This has given us a band of prosecutors around the country that has a background in fraud. We also have a central casework division, the Central Fraud Division, dedicated to this area of work. We're all going to come under pressure to see what our proposals are for dealing with the problems. Our offer is to work with law enforcement colleagues to come up with a joined-up response. So in conclusion, prosecution of organised crime is something that is currently a very real priority for the CPS, and it will continue to be so, particularly with the new DPP, Alison Saunders. The CPS has stated that the NCA is and will continue to be a key strategic partner of the CPS. The same applies to ACPO and to police forces generally. My division will continue to work with the NCA through the national tasking process to ensure that those cases that need to have a specialist prosecution response are identified at an early stage and are prosecuted through the Organised Crime Division. The complex casework units will continue to support the work that's progressed through the ROCUs. In appropriate cases, where a very specialist response is required, a ROCU case can be taken into the Organised Crime Division and prosecuted there. The key to future success will be proper communication and the development of key strategic partnerships. And it's these key strategic partnerships that will ensure that the great progress that has been made in the investigation and prosecution of this type of offending will continue. I think I've overrun slightly and I apologise, but thank you very much.